call the City of West Hollywood Rent Stabilization Commission meeting this Thursday, February 13th, 2020 to order. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Can we have a roll call, please?
Commissioner O'Keefe? Present. Commissioner Kirby?
Here.
Commissioner Maggio? Here. Commissioner Marks? Absent. Commissioner Charity?
Here.
Vice Chair Topchian?
Here.
Chair Bergstein?
Here. We have a quorum. And to item 4, approval of the agenda. Have we all had a chance to review tonight's agenda? Any changes, or I'll entertain a motion to accept?
Make a motion to approve the agenda.
I'll second.
Okay. We have a roll call vote, please.
Commissioner O'Keefe? Aye. Commissioner Kirby?
Aye.
Commissioner Maggio?
Aye.
Commissioner Marks is absent. Commissioner Charity?
Aye.
Vice Chair Topchian?
Aye.
Chair Bergstein?
Aye. Passes. We've got item 5, approval of the minutes from the January 23rd, 2020 meeting. I have one correction. I apologize for not calling in advance, and it's very minor. On page 6, under commission comments, Commissioner Marks was talking about the,
Pop-up.
it's not the lodge, I'm just drawing a blank now. The log cabin, it's not the lodge, it's the log cabin. So minor change, that's the only change that I have to the minutes.
And my only change, Chair, was it's listed me as an abstention. My understanding of recusal and abstention is that recusal means that I didn't participate in the conversation at all, or the item, and so that I would change that to, after that we would change to recused. And that's under the second appeal.
I just, for the record, I was out of the day, and I'm not gonna. I will abstain. I will not vote.
Okay. So with those amendments, a
With those
motion to
amendments,
approve?
I make a motion to approve the minutes.
And I'll second that.
We have a roll call vote, please.
Commissioner O'Keefe? Aye. Commissioner Kirby?
Aye.
Commissioner Maggio?
Aye.
Commissioner Marks is absent. Commissioner Charity?
Aye.
Vice Chair Topchian?
Abstain.
Chair Bergstein?
Aye. Passes. Moving on to item 6, public comments. I don't have any public speaker slips. Going on to item 7, Mr. Noonan, the manager's report.
Good evening. This evening, we do have one appeal, and then there's 2 items on your new business, one of which is some code amendments related to relocation fees. And the other item is a request to designate a commissioner and an alternate to the Climate Action and Adaptation Plan Working Group. On February 27th, there's also one appeal scheduled, and that evening we will move the broken elevator discussion to, which is actually listed on the look ahead for tonight, but that will be moved to the 27th. March 12th, we do not have an appeal at this time. However, we do have information on the rent stabilization ordinance's deposit interest formula, and looking at that and considering if perhaps there's other banks that the commission would see as appropriate rather than the banks that we use right now, which are the local banks here with physical locations in West Hollywood. On March 26th and April 9th, again, the chambers are unavailable. We have gone ahead and reserved the room at Fiesta Hall, and we are set up with to be televised, and so we will hold the meetings there. That is at 1166 North Vista Street in Plummer Park. Anyone that would want to come to the meetings could park either at the north parking lot or the south parking lot at Plummer Park. That concludes my report.
Do you have any questions for Mr. Noonan at this time?
Yes, I have one on the CAAP. Do we know how many meetings that will be?
We don't. I can see if I can find out by the time that item comes up, though.
I mean, do you think it's a long a month, or you don't know? All right, you'll find out. Thank you.
Any further questions for Mr. Noonan at this time?
No.
Move on to commission comments. I have one. I'm just going to pass down the line. We have a copy of the adjournment motion in memory of Detective Amber Lease, and there's a signature line for each of us. I'll pass it down and ask that you sign it, and then I'll mail it to her family.
Very nice.
With that, we'll go to item 9, which is our appeal D4477, 384 North San Vicente Boulevard. The appeal was filed by the property owner, Mr. Ronald Singer. Mr. Singer or representative, are you present? Okay. And then the tenant is it Sherry? Sherry, am I saying Sherry Wang? Okay. Just going to read this is in each of the packets that generally goes out, how an appeal works. When a party appeals a hearing examiner's decision, the commission's review is limited to the examination to whether the substantial evidence supports the hearing examiner's findings. The commission does not reweigh the evidence or substitute its judgment for that of the hearing examiner. So what that means is when it comes time for each of you to present your portion, we can only review the facts that are currently in the record. So we can't hear any new evidence. If you attempt to bring it into the record, either myself or one of my fellow commissioners or staff will kind of cut you off at that. So the way this works is our staff attorney will make a presentation, a report to the commission. We'll have the opportunity to ask questions of the attorney, and when that's finished, the appealing party, which is Mr. Singer, your representative will speak first. You will have a total of 5 minutes to speak. You can break that time up into initial comments and save some time for rebuttal if you wish. And after that, the tenant, you will speak. You have a total of 5 minutes. You do not get rebuttal time. And with that, can we have the staff report, please?
Thank you. Sherry Wang moved into 384 North San Vicente Boulevard in June of 2017 on a 2-year lease. On August 1st, 2019, following receipt of a rent increase notice at the end of the lease term, she applied for a determination of the maximum allowable rent and whether the landlord had retained rent in excess of the MAR. The hearing examiner found that the initial rent for the tenancy was $3,990 and that because no re-registration form was on file, the landlord was not eligible to impose any annual general adjustments. As a result, the hearing examiner determined that the MAR for the unit remains the initial rent of $3,990 and that the landlord has retained rent in excess of the MAR in the amount of $331.70. Staff recommends that the commission affirm this decision. There is substantial evidence supporting the hearing examiner's determination of the MAR, and there is also no dispute that the unit has not been re-registered. Thus, the RSO mandates that the MAR remain the initial rent. There is also substantial evidence supporting the hearing examiner's conclusion that the landlord has retained excess rent in the amount of $331.70. There is also no dispute that Ms. Wang paid the increased rent that was demanded of her, and the difference between that amount and the MAR is $331.70. Thank you.
Any questions from Ms. Regan at this point?
Yeah, just one question. Excuse me. Just one question. Is it your understanding that there was no conflict or discussion regarding the $6 pass-through in the hearing, meaning the landlord wasn't claiming that they were trying to pass through the $6 in originally? Because that would affect the outcome if they had made that claim.
There was no discussion about that.
Thanks.
Further questions at this time? Thank you. And with that, the representative for Mr. Singh, you can come to the podium. Before we begin, if you'll just state your name, your city of residence, and then let our secretary know how you'd like to divide your time.
Name is Karen Burkholm Vogel. Reside in Glendale, California.
And how would you like to divide your time?
I don't need a rebuttal, so
Okay.
this is fine. The primary reason for filing the appeal was to establish that the lease agreement was clear that the rent was $43.90 with a early pay discount of $400 per month, which would reduce the rate to $39.90. That was communicated to Ms. Wang before lease signing by the leasing agent, Thomas, but he was not able to make it this evening, so. We have it both in writing and orally, and the only thing that I wanted to basically get agreement on was that the lease was in proper form and that it did establish the rent at that time as being $43.90 with the early pay discount, which Ms. Wang definitely took use of, and we don't dispute that she paid $39.90 throughout the term, full 2-year term of the lease, and that's because the rent incentive works. We find that there's no incentive for the tenant to pay on time, especially with a 1% limit on a late fee. So this is a practice that Mr. Singer has used, and it's effective. We are not disputing that $33.90 is the amount that she was paying, and we did fail to re-register the unit. I was not aware that was a requirement. I've always registered the units each year, but I didn't recognize that was in addition to actually registering each lease or unit. I'm aware of that now, so I have registered the unit on the new landlord portal. And we are, like I said, we're not disputing that that she's been paying $33.90, and we will concede that that is the maximum allowable rent per the staff's decision. I'm just looking for some direction, I guess, on how to address the lease agreement, which did address the rent as being $43.90 with this early pay discount, which is both it's identified as the amount of the rent in the lease, and in the addendum, it's explained that the discounted rent is the $39.90. So.
You keep saying that you acknowledge the rent is $33.90. I think that you're speaking $39.90.
$39.90, I'm sorry. Yeah, it's
Commissioners, do you have-
$43.90 was the.
Commissioners, do you have questions?
Just a quick one.
Excuse me.
So just to confirm again, the tenant has never paid $43.90.
No.
And never paid late fees
Right,
during this 2-year contract
right.
period. All right, thank you.
Any further questions? Okay, thank you. You can take a seat. Ms. Wang? And again, just for the record, if you'll state your name and your city of residence, and then you have 5 minutes to
Wang.
speak.
West Hollywood, 384 North San Vicente, and I've been there since July 2017. I understand that the lease agreement that was there, I like to just step back from the process of me finding this particular listing for rental on Zillow. It was listed as $39.90 as an advertisement, it's like, this unit with pictures and everything. And if I've gone back recently to look at the history of the price, it was listed as $39.90 in May 2017. The listing was removed in June 2017 when I signed the lease as $39.90. So from the front, it was advertised and presented to me, it was $39.90. On the day of the lease signing, I was presented with the lease agreement for the first time. On the first page, it says $43.90, and I was really shocked. I'm like, wait, it's $39.90. Why are we talking about $43.90? The leasing agent says, the rent is $39.90. Just pay it on time. You don't have to worry about it. He goes, it's a heavy penalty if you're late. This is just a way to prevent you from paying the rent late. So he made me initial the addendum about the explanation about the $400 discount. At that point, it's sort of like you've gone through this whole process, you're at the unit getting the key. So I signed it, and I immediately scheduled payment for $39.90 at the 25th of every month for the following month to make sure that the rent gets there no matter what on the first of the month for the rent. And I was never late one time. I showed records of all of my bank statements of the payments. Now, when the 2-year lease was up and the rent increase came, they used $43.90 as the base to tag on the 3% increase. So all of a sudden, when you really calculate from the expected rent that I have to pay, which is, I believe, come out to be $43.27, minus $39.90, it was close to a 9+% increase. That's what brought me to call the rent stabilization board to find out, is that okay? Because I got a newsletter from you guys that said the current allowable lease rent increase is 2.25%, and then that's how we started this whole thing. So ever since then, I was being told that pay the increased rent amount that the landlord demanded until there is a decision made that's final after if there's appeal process. It was explained to me, this whole process, and I have been paying diligently since last September. So I've total paid 6 months of the extra of $331.70 in question, not just the first month, because when I first had the hearing, I've only paid 1 month at a time. So today I have consistently paid that amount. I just want to go on record to say that, and I do have additional bank statements, but I understand that I'm not supposed to introduce new evidence. But I want to just make sure that that's understood. I've not just paid one payment of the $43.90, whatever the new rent that was demanded. I've been paying that every month. I have no problem to pay a rent increase. I understand within the city limit, rent needs to go up, just like a cost of living adjustment as wage increase, and that's totally fine. I just don't agree with the fact that this sort of a bait and switch using a hefty discount and then call it rent and then make that a rent increase as a base. And I don't feel like that is really a proper business practice. I understand, of course, that it is effective because it is so steep that I would never want to pay extra $400 a month just because I'm a day late. So I make sure that that doesn't happen. But at this point, it's presented to me that that discount is discretionary, and that's what they use they took away the discount from now on with the new lease or whatever. Once your leases expire, you're on month to month, your discount is gone, and that's whatever the new rent is. And again, I don't agree with that position because $39.90 was the initial rent payment that I made. I made a 2-month security deposit, which is also on a copy of the first page of the lease. That's $79.80, which is $39.90 times 2. So with all indication, my understanding going to this lease is my rent is $39.90. And if you're going to increase it, use $39.90 times 2.25. I'd be happy to pay for that, going forward. And as long as it's within the city ordinance of the rental board's decision. So that's what I have.
Ms. Wang, so you fully understand when you signed the rental agreement that the line where it says that the tenant agrees to pay $43.90 per month for the term of the agreement. So the addendum, and the rental agreement is signed, and the addendum is signed by you. So the addendum explained that $400 discount is the early pay discount.
Well, I don't, first of all, early pay means I'm actually paying the rent. Rent is due on the 1st. That's universal, so I make sure I pay rent on the 1st. They're just saying if you don't pay it by the 5th, you lose that $400 discount, which the rental agency, the agent, Thomas, was like, as soon as you pay it by the 1st, you never have to worry about it. Your rent is $39.90. It's not $43.90. He goes, that's just paperwork. I'm like, okay. At that point, I'm getting the key. I'm moving out of my apartment from Beverly Hills. I gotta go somewhere. So I didn't really feel like, I don't like that part of the agreement, but I signed it, yeah. I mean, my signature's on there, and I initialed the addendum and immediately make sure that I do not violate that rule that the landlord set, and I respect that. As a landlord, you have to protect yourself.
Okay, thank you.
Just wanted to clarify, I didn't quite understand, the rent that you are currently paying, are you paying the amount that the landlord demanded each month since then?
Yes.
Okay, thank you.
In full.
Thank you. Any further questions? Mr. Corpes?
One last question, just clarification on when you, the story you just spoke to us about, I don't remember the rental agent, but yeah, Thomas. When you did you tell the hearing examiner that the explanation that you just provided us?
Yeah.
Okay, thank you. Thanks.
Thank you. Did the landlord's representative have any time left? Okay, you can have a seat, ma'am. Landlord's representative, if you'd like, you have rebuttal time if you wish to say anything.
I have in front of me the email from Thomas to Sherry Ray when they were negotiating the lease. And the email's dated May 30th. I don't think the lease was signed till June 1st, I guess. So, and in the email, Thomas did notify her that the exact terms, that the lease would be $43.90, that there would be a $400 early pay discount written in that would be applied as long as it's paid by the 5th of the month. And the discount, it was explained to her that it would, at the term end of the lease, that it was up to the discretion of the landlord whether to reduce the discount from 400 to 0 or anything in between. And he explained to her those were the terms and was she willing to accept it. So I'm not aware, he's not here, so I can't know whether she had time to review that before the actual lease signing, but it was made clear that that was the arrangement. Like I said, we're not going to dispute the MRA being at $33.90 because we did fail to register the unit. If we had registered the unit at the time, we would have registered it with the
That's time.
the appropriate rent, and
you.
it could have been, resolved then.
Commissioners, any questions? Thank you. With that, we'll begin our commission discussion. Who would like to begin?
I have a couple of concerns here. My main concern is that, and I wouldn't say it's a question, it's just it's a thought or it's a concern maybe. The tenant has a rental agreement that clearly states that the rent amount is $43.90. On that first page, there is no discussion about the rent discount or early pay credit or anything like that. So the tenant signs it, and then an addendum is offered. And the language of the addendum, it doesn't mention anything about the early pay discount. That's what was, I guess, mentioned at the hearing. To me, it is a rent, it's sort of a rent concession or rent discount that the tenant had, because the language of the addendum says, if you pay, the language of the addendum basically provides 5-day kind of a grace period. If you pay before the 5th, you're paying $39.90. If you pay after the 5th, you will pay the full rent plus the late fee. So I don't really see it's an early pay discount. To me, it's a rent concession. And if it's a rent concession, so my understanding, and I want to hear from the fellow commissioners. So the rent concessions, I believe they are allowed, or at least I don't see anything in the RSO that would state otherwise, unless if there is a definition or rent concessions or rent discounts or rent credits explained somehow in the RSO, defined somehow in the RSO. But what I see here is that the landlord and tenant, upon initiation of the tenancy, entered into agreement and set the rent. They set the rent at $43.90. That's their agreement, and the part of the agreement was if the tenant pays within the 5 days of the month, within the first 5 days of the month, that the tenant gets the $400 credit. I don't really see that under the RSO, the rent amount is $39.90. I believe it's $43.90. Thank you. And another thing, I agree with the AGA. It should be 2.25 instead of 3%. Thank you.
Commissioner O'Keefe?
Yeah, I agree with the hearing examiner and the staff analysis. It looks pretty clear in the RSO that rent means the consideration paid for the use or occupancy of a rental unit. The consideration paid every month was $39.90. It's quite clear also in the RSO that the late fee may not exceed 1%. Whether or not a landlord thinks that's fair or sufficient is irrelevant. They cannot. I see this lease as an attempt to circumvent the very important purposes of the rent stabilization ordinance. First, rents cannot be increased by more than the AGA each year. Were this to be allowed, the actual rent accepted and demanded for several years was only $39.90. To allow a landlord to have a provision that has one supposed discounted rate that can then be far higher allows them to circumvent the limit of the increase that's allowed each year, and it allows them to circumvent the limitation on late payments, both. Neither of which I think are permissible, and I think it was well thought out that the rent stabilization words it in a way that rent is what's demanded and accepted year after year, so no language can circumvent the core purposes of that, either for rent or the late payment. So I would uphold the hearing examiner's decision.
Commissioner Martz?
I would agree with Commissioner O'Keefe. I think also when we look at contracts, if there are conflicting terms, which the addendum could be considered conflicting, and then the lease is different, even though I think the addendum is just poorly worded. The conflict is construed against the drafter. That's contract law, and in this situation, it's the landlord that had the power to dictate the terms, and unfortunately, if there's errors or concerns, it usually goes against the person that had the chance to write it. And I think in this situation, it's pretty clear that $39.90 was what's been collected, demanded, received, just like the language in the RSO for multiple years at $39.90, and so I would uphold the hearing examiner's decision.
I'm in agreement with my fellow commissioners, and also just, piggybacking on Commissioner Martz, the lease is a contract, and in contract law, you cannot have terms in a lease contract that are contrary to the jurisdiction where the contract is drafted. And the jurisdiction here is the West Hollywood Rent Stabilization Ordinance. So to address my fellow Commissioner Topshin's concerns, the rent isn't what they say it is in the contract. The rent is what the West Hollywood Rent Stabilization Ordinance says it is, or the West Hollywood Municipal Code says it is. And in the West Hollywood Municipal Code, it defines the initial rent as the monthly amount actually demanded, received, or collected. So I understand that you may think because you drafted these terms in a contract and both parties agreed to them, they cannot be contrary to the laws of the jurisdiction of West Hollywood is the issue. So with that being said, I did see the same issues that Commissioner O'Keefe saw, especially in the appeal on page 13 of our packet, page 2 of the appeal. In the first paragraph, halfway through, it spoke of, and further, Ms. Wang was notified at the end of the 2-year term, it would be up to the discretion of the owner to reduce the discount or not from 400 to 0 or any amount in between that he chooses. And that discretion of that amount that the tenant has to pay is exactly what the Rent Stabilization Ordinance is trying to prevent. It's trying to prevent a wild swing in the amount that a monthly tenant has to pay because we're trying to stabilize the rent increases versus have it be purely at the discretion of the landlord or the parties. And what I'm trying to hammer home is it's not at the discretion of the landlord or the parties. It's at the discretion of the West Hollywood Rent Stabilization Ordinance.
Mr. Kirby's?
I would agree with everything that's been said so far, my fellow colleagues. Thank you for following up on that part. That's the only thing I was going to add, was that this really is an example of why we have the law the way we have it. Whether intentional or not, I think it shows, it sets out a pretty good example of what it is that we're trying to avoid. And so I would also agree to with the hearing examiner's decision.
Commissioner Maggio?
Well, it's certainly an interesting concept, this incentive idea. Penalty really high. It's unbelievable. But it's not about any of that. It's really about a no registration form, which was not filed, and so therefore the landlord is not entitled to impose a general adjustment. So I will uphold the hearing examiner's decision.
Just a quick question for staff. The tenant mentioned during her testimony she's continued to pay that higher rent, and in our record, we're only showing the overpayment of $300 something. Would there be something in our decision that would reflect all overpayments? Would we credit back, or is that not?
No, so the commission would either affirm or not the hearing examiner's decision, but going forward, in order for, and we can explain this afterwards too, but in order for the landlord to impose the AGA, they would need to refund all of the overpayments, including the ones that have been paid since the hearing took place.
Thank you. So I am the only landlord on this commission, and I see this kind of example of a landlord trying to offer a big carrot with a big stick behind it, which is not allowable under our ordinances. Really what this was a really excessively high late fee of that, what you're calling a discount of $400. In addition to that, you also reference a 6% late fee on top of the loss of that early payment discount, whatever you want to call it. Late fees in West Hollywood are 1% of the rent, so the most a late fee could have been would, excuse me, is $39.90. We have ample evidence in our record that shows that the tenant consistently paid $39.90 each and every month, never late, always on time or early. And again, the landlord attempted to use the AGA from the prior year, and we go by a calendar year, so that initial calculation, even if you'd filed the re-registration, was the incorrect year. 3%, only 2.25% would have been allowed if you'd re-registered the unit. Excuse me. I just wanted to note to the tenant, part of the record, you brought up that you felt that the city held a file of all leases in the city. We don't have copies of leases. We wouldn't accept copies. What we do is we require all units to be re-registered upon a new tenancy when the unit turns over, not just a roommate, and that document shows who the tenant is, who the landlord is, what the rent is, how many bedrooms, how many housing services. So because the landlord did not file this, that is why the AGA was denied. So I would be in favor of upholding the hearing examiner's decision, and I will entertain a motion.
Can I ask a question
Yes.
to the legal counsel?
Excuse me.
Ms. Elsons, Ms. Regan, well, again, I believe that the rent demanded under the RSO, as the language of the RSO states, it's $43.90 instead of $39.90. That's my belief. So now, how in the light of this discussion, how the rent concessions, rent discounts can be treated if a similar case comes before us. So are we saying that the rent concessions or rent credit discounts would not be possible to?
During your deliberations, I can't comment on a hypothetical. It's not.
Okay, so maybe after the vote.
I'm prepared to make a motion.
I'll make a motion to adopt Resolution RSC 20-570, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision in D-4477.
I will second that.
Madam Secretary, can we have a roll call vote, please?
Commissioner O'Keefe?
Aye.
Commissioner Kirkes?
Aye.
Commissioner Maggio? Commissioner Marks?
Aye.
Commissioner Charity?
Aye.
Vice Chair Topchin?
No.
Chair Bergstein?
Aye. Motion passes 6-1. If either party has any questions, feel free to approach staff. With that, we will move on to item 10, new business. The first one is advisory boards and commission appointment to the Climate Action and Adaptation Plan.
Thank you. Just a brief summary report on the item. In December of 2019, City Council directed staff to update the West Hollywood Climate Action Plan as a next step in helping the city establish an aspirational yet achievable path to further reducing carbon emissions and adapting to the impacts of climate change. So the new plan will be both a climate action plan and an adaptation plan, hence the acronym CAAP. Reflecting that the city's ongoing sustainability priorities and ideally establishing more aggressive greenhouse gas emissions reduction targets and strategies to recover from adverse climate scenarios such as long periods of drought, extreme heat, power outages, and other climate change events resulting. So the Rent Stabilization Commission has been asked to designate 2 commissioners to represent the Rent Stabilization Commission on the CAAP working group, act as a liaison, relaying information from the CAAP working group to the commission and vice versa. So one would be primary and one would be alternate if the primary was not available. The working groups will convene through a series of up to 4 meetings between March and November of this year, 2020, beginning with listening sessions and proceeding through feedback workshops as the CAAP develops. The scope of work includes forming working groups consisting of various stakeholders from the community and city staff. The purpose of the working groups is to obtain feedback and input on the city's sustainability process to date, issues related to the current climate action plan, e.g. energy efficiency, water management, tree canopy and green space, etc., as well as new ideas and aspirations for the plan update. So at this time, the commission is, I turn it over to you, Chair, and the commission could discuss and appoint a primary and an alternate to serve on the CAAP.
Do you have any idea at this point how long this process would be and how frequent the meetings might be? Or is that kind of
the
nebulous?
information that I have is that there's going to be up to 4 meetings between March and November of this year.
Thank you. Do we have any commissioners who'd like to volunteer to serve on this committee?
I'd be willing to. I do travel a lot, so an alternate would definitely be needed if I do.
Volunteer for the alternate slot?
Yeah, I'm just concerned about when the meetings are and all that stuff, but I would be an alternate. I'll attempt to be an alternate.
All right. Thank you very much. That will go on to 10.2, proposed rent stabilization ordinance, language changes related to the relocation fees.
And I'm going to step away and I'll let Gloria Aviles take my seat, who's going to take this item. Thank you.
Good evening, Commissioners. There are 2 proposed language changes that we are bringing to you for further discussion and to provide comments as desired. On February 6, 2017, Councilmember Meister directed staff to amend the rent stabilization ordinance to eliminate forfeit of the relocation fee when the tenant does not move out of the unit in the time frame specified by state law. That would be the proposed code language under section 17.52.020 subsection B. Modifications to the rent stabilization ordinance are completed on rare occasions, particularly because constant changes would affect the integrity of the ordinance. Staff considers if any of the proposed language changes may cause unintended consequences. A prudent review of the current code and an analysis of past relocation assistance provided to displaced households confirmed that the risk of forfeiting the relocation fee when the unit is not surrendered is a useful tool the city's third-party nonprofit relocation specialist and staff use to encourage a person or family resisting the need to remain engaged in actively seeking new housing opportunities. If there was no risk of losing the relocation fee, supporting persons and families resistant to the inevitable displacement by use of the State Ellis Act or only relative occupation allowances would be more challenging. The other amendment proposed is respect to the relocation fees for no-fault evictions, including State Ellis Act and owner-relative occupation, are needed for clarity. Current language in the code has confused members of the public and staff about how to apply the fees applicable for low-income households. The ordinance currently can be read to suggest a household with a low or zero income earning individual automatically qualifies for the low-income relocation fee, when the household itself, considering income from all wage earners, would not qualify. The amended language clarifies what constitutes a household and how income should be calculated. That income is calculated following the guidelines provided by HUD, and the income for the entire household is used to determine the applicable relocation fee.
Commissioners, questions?
Miss, if I may.
If you wish
sorry,
to
sir.
speak as a member of the public, you could come fill out a form, and then you'd be able to speak as comment. Yeah, bring it on down. So it does appear that you have one member of the public who would wish to speak.
We'll hold commission comments till we hear from the public.
If the commission had questions of staff related to the staff report, it would be appropriate to ask those at this time, if you wish.
I just wanted to ask a question about the fees, annual update of the relocation fees. I understand it's based on the CPIA index, right? It's basically, we're using the same percentage as for the rent increases.
We're not.
We're not?
It's a different
That's a
category
different
that is
category.
used.
Okay, so that's the part I probably I was confused. So we're using a different different formula or different?
It's a different category. So
Can you explain a little bit more about that?
Sure. We're just using one component within the CPI. It's the component for housing. And so the CPI is made up of a number of different troughs. So we've just specifically narrowed it to the change in cost of housing is what we use to adjust the relocation fees.
It's not a percentage, or it's a component?
It is a percentage.
It's a percentage.
So CPI, the Consumer Price Index, is made up of a trough of different goods and products, and one of those is housing costs. And so we've targeted the increase in the relocation fees only to the housing costs. This is consistent with how Santa Monica also applies their increases to their relocation fees.
And the reason, Peter, I'm asking this question is because, so I understand, I read it, so it always will go up even if the CPIA for the rent increases will remain zero, right? It's, like when we had years for no rent increases, but for relocation fees, the percentage will always go up if it's a different category is used?
Well, it's a subset
Component.
of the CPI, and so if the housing, so if increases in housing costs do not go up, it would be zero. But there could be a case where the housing cost does go up, but other goods and services go down, and so the CPI itself is negative or at zero, it is flat, where in fact the housing costs could also escalate. So there could be a year where we increase the relocation fees, yet the actual rent cap in the RSO is zero.
Zero. So, and that's the exact model that the Santa Monica uses and other jurisdictions, or you mentioned Santa Monica?
I believe that Santa Monica uses the same factor as we do in adjusting their relocation fees, yes.
Okay. So my understanding was that no matter what, relocation fees will go up at a certain percentage. I don't know what's the percentage. I don't know what are the calculations, but my belief was that regardless of anything, so the relocation fees will always go up by whatever percent. But that's apparently it's not the case really.
Correct. We don't have either a floor or a cap set on our relocation fee increase.
And that's the same model that the other jurisdictions have. So it's not.
Yeah, I don't believe any jurisdiction has a minimum increase on their relocation fee.
Okay, I wanted to clarify that. And the another comment I want to make is about the no waiver clause, that finally, I'm really glad and I'm happy that Council Member Lauren Meister took a lead on recommending this. This was something that I discussed with staff and years ago. I believe that provision should have been revised, and I believe that was wrong and unfair to have that waiver clause. And finally, after so many years, I'm really happy to see that this change is going to happen. And thank you, staff, for that.
I echo those exact sentiments. I think it's nice to strike that clause, and I think the reasoning is sound. And I also think clearing up the confusion about the valuation of the household income is good as well.
Sorry. Rich Garpies?
Yeah, you mean perhaps before making deliberations or statements, you'd like to hear
This is
from
just
the
questions
public?
for staff? Further questions for staff? I have a couple. Hi, Gloria, I didn't see you come in tonight. Nice to see you. If you can break it into simpler language for me, and I had a little difficulty with the document, with the strikeouts and things. Subsections A through D, the language about all tenants living in the dwelling unit are collectively entitled to the relocation fee. Do I understand that to be there is one relocation fee paid per dwelling unit, not one relocation fee if there's a two-bedroom apartment and there's 4 people living there, not four separate relocation fees?
Right, the relocation fee is for the dwelling unit, not for each tenant.
Okay.
The thing is that, let's say, for example, there's 3 tenants, and one of the tenants is low income because they're under Social Security, for example, and the other 2 tenants are making $150,000 a year. Currently, the way that the language stands is because there is one lower income tenant, then everybody shares the higher lower income relocation fee. What this is saying is that if it is a household, meaning if those 3 members of the tenancy are, for example, mother, father, and adult son that's receiving the Social Security income, and the parents are making this amount, then the entire household is considered the income and not just an individual. Now, if it's 3 roommates and they're all going to live in separate places when they're displaced, then the lower income bracket does apply in that situation.
That was my second question. One last question. I know the city contracts with I think it's the Alliance for Housing to assist tenants with looking for new places to live when they are being evicted through no-fault eviction. Is there a service through that organization also? There are some landlords who are not, don't have a lot of discretionary income that maybe eking by, and if there's a hiccup in the process of perhaps moving in a family member, is that organization available to help them, or are there no resources at this time available to assist a kind of a low-income property owner?
I believe the contract is only to assist tenants that are being displaced for no-fault evictions.
Okay, thank you. Any further questions for staff?
I do now.
I have a clarification. In your staff report here, the paragraph at the bottom that goes into page 2, I understand that to read that staff may not be fully in favor of this change. Is that because the forfeiture language that's currently in the ordinance that is going to be stricken is a useful tool that the relocation specialist can use as kind of a stick if the carrot of the money is not working? Is that proper
That is
reading?
correct. The experience has been that when this is shown to the tenants that are being displaced, it keeps them actively seeking for housing opportunities. Otherwise, they tend to want to stay as long as possible, even up to a point where they don't care if they're going to get evicted or anything like that. So we want to make sure that they're fully housed, even before this time that they need to be vacated. And in order for us to do that, this is one of the things that we say, hey, you're at risk of losing the relocation fee if you don't, obviously it's a big change for people, and when people aren't open or welcome to change, so it's really hard for them to get them going. But this is like a little fire underneath their feet that will help them, in the process.
Okay, and can you speak to what other jurisdictions do? Do they have a forfeiture language in their ordinances, City of Los Angeles, et cetera?
I don't think we did any kind of research in respect to that, but I can get back to you guys if that's what you would like.
Yeah, we don't know if that's the case. However, we also know that there's not many jurisdictions that provide the level of relocation support and assistance that we do.
I can also speak to Los Angeles does require forfeiture, so the City of Los Angeles. And then,
No, it's not true.
okay, I disagree. And then lastly, can you speak to any specific examples of people? Have you had experiences where people have not wanted to move? Is this something that comes up in these relocation situations?
I don't have any specific examples, but I know AHH has expressed to us that this has helped them to keep people engaged.
Okay, that's all I have. Thanks.
Further questions for staff? Mr. Kerpes?
Yeah, I have questions about the answer that you provided and what I'm reading here about the way the the amount is determined. Can you go over that one more time? So there's households that have non-family members, and there's households that have family members that plan to move out together. They would get different amounts based upon what their intentions are?
Right. Currently, our ordinance says that if there is a low-income tenant, they're entitled to the low-income relocation fee. This just defines what a household is. And for example, we were seeing couples, married couples, where the husband was fully employed and the wife wasn't, or was a part-time worker. And because she was part-time, then she actually, based on our current language, she qualified for the low-income relocation fee. But if it's a household, then you have to take both incomes into account. And this is what this code language is going to do. It's going to clarify that a household income is based on the members of the family.
But what I'm reading here is that, like in C, you've got persons and families of moderate income. You add all those together, and that's what they're entitled to. Yeah, or you add all. I'm not understanding how you're defining it or why you're defining. Either we go with the household, meaning everybody who lives in the residence, or we don't. I don't know why my understanding is you're telling me that if the two of us live together as roommates, our incomes don't combine to form one household income, but yet if I am married to somebody, it would combine together.
Let me jump in to provide maybe a little context. So our relocation fees are based on costs, our understanding of what the average costs are to relocate from a unit. And so the base fee is based on how many bedrooms are in the unit, assuming that a person that is in, or a entity, a group of people in the 3-bedroom is going to have more belongings, therefore more cost to move than someone that's in a studio. What we were seeing, however, is that in certain situations in West Hollywood, you have roommates living together that are not commingling their income. They are essentially two independent households that are living in one unit. And in cases where someone was of means and they received the relocation and they're gone, but the other person was earning lower income and struggled. And so we wanted to make a case, because before we made this change in 2014, we would just apply the one fee. Didn't matter if you had everybody, or if there was one person that was over income in the household, in that unit, then nobody would qualify for the low income fee, even if they were not commingling funds. And so we made a change so that we would base it on household income. The language, though, was confusing, in the code was confusing to staff and to the community, although it does point to the charts for household income that's put out by HUD. And so even though the code does say tenant or person, you can't actually calculate a person's income without knowing their family, their household, because the household, the rates are set up for households. So the language change in the code is clarifying, in fact, that it is household income that we're looking at, and that household is based on who is commingling their funds, who is intending when they are displaced, because these are funds to help you relocate because you've been displaced, that when you are displaced, what is your housing unit that you are being displaced in? So if you are a husband and wife, and you're just, or a husband and husband, that you're married, wife and wife, and one is, your partner is working and you're not, that doesn't mean that you're low income. It means that you're part of a housing unit that one breadwinner is earning, and you are, fortunately, you're able to not work while they are. That's all this code is essentially doing, is just trying to clarify the simple fact that we're trying to provide a benefit to a tenant who happens to be living in a roommate situation, but is not earning as much as their roommate.
So how would you walk me through this? So the two of us are living together. I'm low income, he's high income. We both have to move out. The city knows or doesn't know whether we're going to move together or not into the next place.
We
I'm not
do,
understanding.
actually. We will eventually know, because we have our housing relocation specialists. So the first thing that happens is, for the initiation of the Ellis displacement, you would receive a fee based on the number of units in your bedrooms in your apartment. So let's say you're in a 2-bedroom apartment, you would receive the 2-bedroom fee. But then you would have an appointment scheduled with Alliance for Housing and Healing, which would assess your housing needs and determine how they could best support you in your relocation. And as part of that, they would also calculate your income, or help you with your income, to see if you qualify for any housing programs, including the city's inclusionary housing program, because you both would receive a priority within that program as displaced households for units that come available in the time period where you're looking for housing. And so in that process, we would determine, Alliance for Housing and Healing would determine what your household entity is, because they're helping you find new housing. So if the two of you are actually planning to move together and move as a household unit, we would calculate your incomes commingled together, or Alliance for Housing and Healing would. If the two of you are planning to not live together, you're going your separate ways, your household income would be calculated as your individual incomes.
So wouldn't it be to our benefit to do the math and figure out which is the most financially beneficial? I mean, I guess I don't understand.
Well, there's always ways of working around things, and you could always try to find a hole through the rules. We're not trying to create a situation where it's a workaround. It's just simply, we're trying to meet a need that we see out there in the community, where we do in fact have roommates that are living together, that the two of them are not earning the same. And we wanted to be able to provide a benefit for that roommate that, for instance, has taken on other roommates because they can't afford the rent themselves. But when they're displaced, they could use that little bit of extra help.
So doesn't this almost put at the back end of it, or the front end, I should say? So the person that's costing the money to is the property owner. So doesn't that entice them to make sure that their tenants are as wealthy as possible?
How would you do that?
Well, I'm not, I don't.
I mean, I just don't want to do anything this seems, it seems like it's not, doesn't create any stability for the property owner. Not that I'm very sympathetic to them. They're going to make a lot of money off their project if they're Ellising people out, but at the same time, there should be some reasoning or stability. And this, to me, seems like it would be very easy for, and they should get the most amount possible under our ordinance. I guess I don't know what to compare it to. So how does our current ordinance work?
I should clarify that we're codifying current practice, and this current practice has been in place for 5 years, and it's working.
Go ahead.
Gloria, if there are 3 people that are entitled to the relocation, is it the responsibility of the owner create the division, or does he pay one amount to one person and they're responsible for the other two?
It's my understanding that a check is provided with all three names on the check.
Oh, so that,
Our ordinance doesn't indicate who gets how much. That's between the tenants. They get to divide that amongst themselves. Our ordinance doesn't say who gets what percentage.
so therefore the check cannot be cashed unless there's 3 signatures?
Correct.
All right, thank you very much.
While this ordinance is being revised, I wonder if it's worth considering revising that. I wonder if that's caused conflict. It seems like it would be more fair to ensure that, that it's divided up among the tenants or the master tenant and the subtenants instead of just allowing it.
I think right now we're just at questions for staff. Maybe you want to bring that up during deliberations?
Good point. I was
Just
going to ask
questions
the
for staff
similar
at this point.
question and then
Not quite there
got the
yet.
answer. You're right. Thank
You
you.
have a question for staff? Okay. So I think that's it for now. Mr. Brown, are you speaking on this agenda item or just on rent stabilization in general?
I was talking about this one, just hearing some things that
Because if you'd like to speak about this particular agenda item, I'll bring you up now. If not, we have public comment towards the end of the meeting. If you want to speak generally on rent stabilization.
We'll talk about this now, sure.
Okay.
If I say something at the end, I say something at the
All
end.
right. Just
Hi,
your
my
name.
is David Brown.
City of
I've lived
residence.
here in West Hollywood
Okay.
for, a little over 8 years now. Don't mind the gray. So my initial question would be, what of our current practices has borne or suggested the issue or problem with the cost of living adjustment and moving not going up? Because as far as I see it, when you're moving, that's going to be more expensive than when you moved in, whether you're moving to another city or another state or anything like that. If you're packing up here in California and you're moving across state lines, that's expensive. If you're packing up and moving across town, that's expensive. And it's more expensive, just generally speaking, than when you moved in to begin with. No? I mean, one can conclude, that's everything else is going up. And my thing is that wages aren't. So it's going to be more expensive. I'm making 50 cents to maybe $2 more than when I moved in 5 years ago. And now that I have to move, oh, holy crap. I really had to edit myself just then. I had to think about that one. But it's like, wow, things have gone up. When you look around 5 years later outside of your own neighborhood, even if it is to another community that is a step down as far as affluence goes. So I don't know. I don't understand why that's part of the conversation as far as a concern.
We're unable to answer your question.
And that's an answer. Hey, because if you know what, if you had the answer, you probably would have said it already. But yeah, that was my main concern.
Okay, thank you.
Thank you.
And with that, we'll begin deliberations. Commissioner O'Keefe, would you like to start?
I think it's worth just noting for background that the city of West Hollywood has long been opposed to the Ellis Act, which allows people to be forcibly removed from their home. They've lobbied against it. They were unsuccessful and had these relocation fees as something to soften the blow and to cover costs of relocating to a new apartment, which the city wishes were not something that happened ever. So on the specific piece, I'm concerned that staff is concerned that the change of the waiver language might actually make it more difficult to get people into new housing, and it sounds like it could actually result in a more traumatic situation if somebody ends up waiting till the last minute and then they end up going through eviction proceeding too instead of having more planning. I put a lot of weight on that concern that this incentive has helped people get rehoused more quickly instead of waiting till the last minute. In terms of the second section, as I noted at the wrong time, I think that it might be worth considering adding some language if that section is going to be revised anyways to ensure that there's equitable distribution within a unit, because right now it just says collective, and the person with the most power to convince their roommates might not be the person who needs it the most, and it might not end up with equitable distribution. So it seems like it might make sense to figure out something to, I don't know if city could review it. I'm sure staff would have recommendations if they were asked based on what they've seen happen. But it seems like something should probably be done to make sure it's not just whatever is at the whim of the people that get the check. That's it.
Martz?
I echo the concerns about taking away the forfeiture language. I practiced landlord-tenant law for a number of years. I've represented tenants and landlords on both sides of the situation. I have had more than one tenant that does not want to move, even though they have to move. And that was the only way that we convinced the tenant to leave, is because there was $20-some thousand sitting there waiting for them to leave. And without that, I don't believe they would have ever left. I've represented landlords who have wanted to do X, Y, or Z with a property, and they've had to wait 6 months to try to get someone to leave. And, I've said many times, I'm very passionate about tenant rights, but I also understand property rights for landlords. And to take away this stick, which is not that big of a stick, you're saying, here is $25,000, please take it and go, doesn't make sense to me. And I foresee this leading to more evictions and Ellis Act issues if we take away the stick and the landlord gets frustrated. Landlords generally will listen to their attorneys, but at a certain point they, will go full explosion on the situation, and that's going to lead to tenants being evicted without any benefits. And, $25,000 is a lot of money to help them move, which they have to do under the RSO. So I think taking it away, this forfeiture language is a terrible idea. I think the cleanup language on the relocation amounts and whatnot is, it's the practice we're doing now, apparently, and so codifying that, I do think that there are always opportunities to make it better. And I do share some of the concerns I think that you noted about how we distribute the money. I can see, 3 tenants fighting over the money, saying, well, I've lived here longer, I'm going to get more money. You're living in the smaller bedroom, you should get less. There's all of these complications. My only concern about trying to go down that road would be how deep we want to get into people's lives. And, government intrusion of that, I could see that being very difficult. So I see both sides of that. Those are my comments.
Commissioner Maggio? Okay. Speaking to your microphone.
I've asked my questions, and I've been listening very diligently, and I agree that there are a lot of these concerns. I think the only thing I would add is that if there were 3 people, it would seem better for the landlord to actually cut 3 checks instead of 1, and then it's directly given to those individuals.
Mr. Kerpies?
That's all I have.
On the first item regarding the forfeiture, I think I understand the intent behind Councilmember Meister's idea, and I think that it was well intended. But I'll defer to staff on that if that's the if that's going to create a problem. I'll defer to staff because they're the ones who deal with this, and I think it is the example of our fellow commissioner who deals with this stuff as well. He also recognizes that, and I think that so I'll defer to them who know. In regards to the changes, it may be the way we practice it, but I'm quite confused as to how a check is written with all 3 people, but yet it almost seems contradictory that we're now, or that we, in the questions I was asking, it had to do with each of our individual family makeup and our incomes, and the two of us might have, he's high income, I'm low income, so, and we're not gonna move in together, so I'm gonna get a different amount associated with me, and he's gonna get a different amount associated with him, but yet both of our names are gonna be on the check. So when I go to the bank, I get half, or whatever he's willing to give me, and whatever I'm able to give him, it's not, I get more and he gets less. Obviously, it's not as, I have no comments on this really, because if it's so perfect, then we wouldn't be discussing this tonight. It is a change in what we understand, or at least of what I understand occurred. So I don't have any other comments other than that, because I was told this is the way we do it.
Charity?
I don't have much more to say other than my earlier comments. I agree with Commissioner Topchian about the waiver language being struck, and I understand the household distinctions that were made earlier.
Thank you, Chair. Just first want to apologize, Commissioner, when I jumped in with my comment where we're speaking. It was not my intent, of course. The reason I was passionate about it is, as I said, I mentioned at the beginning, I did the research on this item, and my research did not show any rent control jurisdiction, LA, San Francisco, Santa Monica, I believe Berkeley. They didn't have such clause. And when I discussed with attorneys, city attorneys and tenants advocates, the understanding is that if that happens, if there's a notice to vacate, let's say due to Alice Act, and the relocation fees are paid in compliance with the ordinance, and at the end of the 120-day notice expiration, the tenant didn't move out, the remedy will be civil. The landlord has to file an unlawful detainer to get the tenant out of the unit, and in most cases, the tenant would lose the relocation fees, and the judge would order to reimburse the owner the relocation fees. So that was the reason why other jurisdictions did not have such waiver clause in relocation fees provision. And if we use a different scenario, the tenant didn't move out and the landlord says, now you got to pay me back if you're not moving out. So clearly, and the tenant says, I spent everything, I'm not going to pay anything, and I'm not going to move out. What's the remedy? Civil. The owner still has to go through the civil procedure, evict the tenant, and maybe take him to a small claim court for recoup of the relocation fees. So that's why relocation fees are admin fees. They're in the Muni Code, and there was no reason to have this waiver for all these years when there is a civil process for it in the civil court. And that's why I believe and that Councilmember Lauren Meister did a right thing to recommend these changes. I hope this will go into effect. If it's supported by the City Council, I hope the City Council will do that, and I hope the staff will find it supportive. So anyways, that's about the waiver provision. As for the other parts, my questions to the manager was about the relocation fees, whether they're going to go up every year. Ideally, that was my wish, and I wanted to see that the relocation fees in such, especially when we're talking about West Hollywood, when the rents are historically and originally always high when the tenant moves in. They're paying $4,000 or $5,000 rent. And if there is a Alice or demolition Alice Act eviction or some other eviction, the relocation fees, I believe, should always go up because the cost of living goes up. For the relocation services, moving companies, and everything else that connected to it go up. And the rents will go up, and the purpose of the relocation fees is not to penalize the owner. It's not a penalty to the owner, although the landlord community believes that's the penalty, but it's not. That's the money paid to the tenant to help to pack to pack the stuff and move out. So this is to cover relocation expenses. And if somebody is paying $1,500 rent after living 20 years in the unit and has to vacate, and the rent in the area is now $5,000, so that's what we have to think about. So if the relocation fees don't go up, that tenant who will be displaced due to Alice Act eviction or any other eviction will not be possible simply to pay the last month and the security deposit. So, and all other related expenses. That's why I really wanted to see some mechanism that would give at least a floor for the percentage, tiny something that would every year, regardless of the CPIA component, housing component that the CPIA index will be used for, that there is a percentage or something would always be used to increase the relocation fees annually. So, but I guess that's my wish, and I'm not the decision-making person in this matter. Other than that, I would pretty much agree with everything else, and I heard the concerns of Commissioner Kerpes, the questions that you asked, and I would agree with most of them. Thank you.
So the CPI is one of the clearer things for me. CPI has always been, to me, it's like a basket of costs in the region, and we use, I think, 60% of that for our AGA, but we've always pulled out of that basket just the housing cost out for any potential increase in relocation fee. That's always been clear to me. I do appreciate the clarification on, and it gets to be kind of a sticky wicket, what is a household, what is not a household, but I appreciate the fact that you explained that if there are 3 people living together and all 3 are moving together, there's one scenario. If there are 3 roommates who are going their separate ways, it's a different scenario. So I agree with staff's clarification on this. I think, well, Councilman Meister, again, was well-intended. I disagree with her philosophy on this. I think that the relocation fees is a big carrot and a big stick to someone who is being evicted through no fault of their own, and I understand that is absolutely traumatic, particularly with the housing crisis and shortage of housing. To have to find a new place to live is just traumatic when you've done nothing wrong. But I think sometimes lost in the conversation is that we, as property owners, we also do have rights, and the state says that we are allowed to, under very limited circumstances, remove a tenant for no cause. And my concern is that if we are publicly stating that you've gotten your relocation fee, but the city is essentially now going to abandon the process. Well, the city has set the parameters for the relocation and set the fees for relocation. The city's now trying to say, well, now it's between you and a civil court, between you and the tenant and the landlord. That's an abandonment issue to me. We are setting the parameters for this relocation and just saying, just kind of have at it. So I am very leery of removing the possibility of waiving that fee if they do not move on a timely basis unless the landlord agrees to an extension. As property owners, we have plans for our properties, and it can't be tied up indefinitely over a tenant who goes, well, I'm not going to lose my relocation fee. I can stay here longer while we try and keep this going. The question I had for staff about any assistance for a landlord, I know that there's a feeling among many people that landlords are just rolling in the money, and there certainly are the Blackstones, large corporations that are very profitable organizations, but in West Hollywood we are mostly mom and pop, pop and pop, small landlords. And with expenses going up every year, not everyone has a lot of discretionary income. I will tell you that when I purchased my property and had to do an owner occupancy eviction, that money that I was paying out was the last of the money that I had. There was nothing, closing escrow is traumatic enough as it is to try and bring together, and I didn't begrudge the tenant getting that relocation fee, but I really am very hesitant about removing the insistence the tenant move. So I'm not sure, I don't think we're proposing a motion to staff. Are we just passing along our comments in a report to City Council? Is that correct?
The item was if the commission felt it appropriate to provide comments, we could put those in the staff report that goes to the council. The commission does not need to provide the comments if you don't wish.
I would ask that we provide comment, and when is this coming before council?
We'll schedule it for the next meeting, possible.
Sorry.
March 2nd would be the next meeting possible.
Would there be a way for us to review the draft commission comments before they are forwarded to the city council?
Yes.
Okay, if you could circulate those, and then so we don't violate the Brown Act, any responses or clarification, commission, just direct them to Mr. Noonan and have those reflected in with the record. Would that be acceptable to my fellow commissioners?
Do you want to comment on that? I mean, just, if four of us had comments, that would cause a problem, changes to it, because we wouldn't have an opportunity to see each other's and...
Well, yeah, the commission probably, if you reviewed the original staff report, you may see that there's very little room in that original council report for input or advice on the direction. The direction was fairly clear to strike the language. If we were to include comments from tonight's meeting in the staff report, it would really have to be specific to each commissioner, because there's no collective statement at this point to provide as a commission statement. We could foreseeably look at doing that through a blind copy email of just putting out a draft of the minutes, but I leave it to the commission to see what you would like. If that's something, I think that the best way to do this would be to develop a collective statement if you wanted, or not.
It seems as if there was a little consensus on perhaps future clarification on how that check gets divvied up when there are multiple roommates. There was some mixed consensus on whether we should be removing the if they would waive their fee or not. I think I would feel comfortable having both sides of that argument presented in there. And I'm missing a third point that I'm just drawing a blank.
I guess my point, I wanted to set a floor for the relocation fees increases. So that's why I don't think we can do like a combination of, like, you know, maybe what Mr. Noonan suggested, send the commissioner comment format. That would be probably better, in my opinion.
Commissioner O'Keefe?
If it's permitted, I wonder if it might be worth, just for simplicity's sake, having a vote on two separate issues to see if there's a sense of the commission that we oppose or support the waiver, depending which it is, removing the language that's the incentive to relocate, and the same thing for having some clarity to how the checks will be divvied up with multiple tenants. So if that's allowed, I would propose it. And I think it's just a lot clearer, instead of having a bunch of different comments to say we support or we oppose, and here's what the vote is.
Can we do that, like vote on some of the major points just to be included in the comments? We're not making a motion. We're just kind of clarifying.
Yeah, I think the recommendation, it's to receive and provide input. I think you've done that, and so the staff will then take that input that you've given, and to the extent possible, will incorporate that into the staff report to the council, because the council wants to know what your input is.
So you're saying it's receive and file, right, this report?
Receive, file, and provide input.
Can those just be taken from the minutes that are already, or the recording that's already been done, or?
Yes, we can take it from the recordings that has been done, and I think to manage expectations, I think it would be safe for us to make a statement, as was one of the commissioners mentioned, which was there was some commissioners in favor and some not in favor, and some of the key reasons on each side. Hopefully we get that right for those commissioners that are passionate about this.
Speaking with the rest of the commission, I'd like to see a draft of that before it goes.
Yeah, and we'll try to do that. It would be through I think the most logical way to do that would be a blind copy email, if possible. And we can also, I did make a note of the equity or equitable distribution. I can tell you one thing, one reason that we've never done that in the past is because we really don't know how the roommates are living together. For instance, it might be one roommate has all the furniture or most of the furniture, and then the other roommate just has their bedroom belongings, and so there's a disproportionate shift. And so we've always allowed the folks in the household to kind of figure out, or in the unit to figure out how to spread the fees. But we can look at some kind of language about equity.
For what it's worth, it looks like LA has each tenant gets a proportional share of it. Doesn't mean that's the way it should be done, but at least the major city that we border does have something in
Proportional
it.
share?
Correct.
So if we could just get a draft of that in time for our comments back to you before the council meeting, would that be acceptable to everyone? Excellent. And then,
And I think I should also stress that it will be a blind copy email. Please don't talk to one another about your comments. Just direct your comments directly to me.
it's that pesky Brown Act.
So that's what I'm confused about, though. If we're commenting back, what are we commenting back on? It's
Just-
either we accept the document that they do, or we vote on it. Or
No,
we
I'm saying,
sit
like,
here and discuss it. He can't
Personally,
be
I
the-
want to see
Can't be the link, though.
I want to see that the comments I made tonight are included somewhere in that staff report. So that's why I'd like to see the draft.
That's fine, but you can't comment back and say, change this, change that.
I think you
If
can
something
you
were
say
left
it
out, I think I
doesn't.
can.
It does or it doesn't reflect the comments that you provided tonight. You know, I feel this is accurate, this isn't accurate.
Link to your audio statement from here and say exactly what you said. If you said, I meant something slightly different, here's what I said. I'm sure it'll work.
I think going on to page 94, it's not exactly on the agenda, the ordinance, it's the maintenance standards. Are we receiving and filing this? Page 94, 95 through 98 of our packet. Was the maintenance standards for historically significant properties?
So that was an attachment to the council item. So let me explain the genesis of how this item the commission just reviewed and discussed came about. The one item which was on the forfeiture was written so specifically and narrowly that we brought that straight to the council. We brought that along with an item that you recall we mentioned. It had the historic paint standards in it, and it also, I had mentioned that we were making this code clarification from the relocation fee, how we calculate those. So we originally did not bring any of that to the commission itself. So that went to the council. I did send out the note when this memo was written to the council, support as an addendum to that staff report, letting the commission know that if any commissioner wished to see these items first, that we would bring them to the commission before taking them to the council. The chair did ask that we bring them here, and so I asked that the item was tabled so that the commission could look at these items tonight. So the reason that historic paint standard that is in here, it's because that was the original part of this whole package that had gone to the council.
Okay. So no need for us to discuss and make further comments.
No need to discuss.
Going on to item 11, unfinished business, I have none. Item 12, no other public speakers that I'm aware of. Item 13, commission comments. I have a couple. I know you're shocked about that. The staff report for proposed smoke-free housing ordinance is finally on council's agenda for March 16th. Is it possible for this commission to review the draft ordinance before it goes to council? I don't know what the rules are for that.
I can ask, if I look at your calendar here.
The 17th or the 12th of March would be our next two meetings prior to the 16th city council meeting, in case we have further comments.
The
March 16th meeting, so we could either do it on the, 27th is our next meeting, or the 12th of March.
I will talk to the authors. I think that's a pretty tight timeline, and that might not be possible, but I will ask.
If we can, I would appreciate that. To bring up a possible agenda item for one of our meetings at Plummer Park, we haven't had a legislative update in a very long time, and I always enjoy those. They're kind of a more informal roundtable kind of a meeting. Is there any chance that we could schedule that either for Plummer Park or a meeting coming up? And then going back to some old notes, I can't recall, was there a second reading at City Council on the 1-year minimum lease? There was, so that's been finalized? Okay, thank you.
No, not at this point.
Tabled?
Yeah, they did a first reading. They did have it come back. That when it came back, the council indefinitely tabled the item.
So it has not been re-agendized at this point?
Has not been
Okay.
re-agendized at this point.
And then just because I keep asking, have we gotten any update on possible FEMA grant money for property owners to assist in the costs for earthquake retrofitting?
One of the grant applications was oversubscribed, and we weren't awarded. However, the city is still eligible and in the running for a second grant opportunity.
And I think last time you mentioned that one of our legislators had proposed a tax credit, but I think I read somewhere that table did not make it into full discussion. Does that ring a bell?
Is this related to seismic retrofitting? Yes. I believe that you are correct that it was proposed, and you have the most accurate, most current information on that, if in fact that didn't
Mr.
go
Kirby, does that
forward.
ring a bell with you? You're all knowledgeable, not this one.
I believe that it's Nazarian. Don't hold me to
My
that.
guess
but I
is
believe
that it
it
would be
was.
Nazarian, my guess.
I'm sorry?
My guess is also that it would be Nazarian, but I don't know that for sure.
Okay, just curious. And those are my final, they're my final comments. Go on to item 14, staff comments.
I have no comments.
I just have one. I just wanted to let the commission know that per council member directive, I've been working on a proposal for a right to counsel initiative, and I hope to bring that to you all on the 27th. That's my goal for our next meeting, so fingers crossed I get that accomplished.
Somehow I missed the key two words. What proposal?
A tenant right to counsel
Tenant
initiative.
rental council?
Right to counsel.
Oh, okay. Thank you so much.
Any questions for staff?
Probably, Ms. Regan, I will probably follow up with the email regarding the question I asked before concerning concessions, rent credits, because that subject really, I'm interested to know a little bit more about it, so I'm going to send you an email.
And with that, I'm going to adjourn to our next regular meeting of the Rent Stabilization Commission, be held at 7 p.m. on February 27th here in these rooms, West Hollywood Park Public Meeting Room.